Good morning. This is Barbara Melendez and Christina Ruidas. Executive orders. Sounds important, doesn't it? Well, executive orders is a rule or order issued by the president to an executive branch of the government and having force of law. In other words, it is a law issued exclusively by the president of the United States. In late this summer, President Obama, supposedly after the frustration of not being able to get immigration reform resolved through the Congress, decided that he was going to pursue his power as President of the United States to pursue immigration reform through executive orders. Now, this power is issued from Congress and from the U.S. Constitution. The important aspect of this power is, what can we expect? Well, let's step back for a moment and think of what was it that we had. Last fall, the Senate passed immigration reform. That immigration reform included deferred action for childhood arrivals, or these are young people who arrived in the United States. It included all sorts of work authorizations, including for parents of those who arrived in the United States at a very young age. Some of the areas that the president is going to look at is issuing work permits for those parents of DACA recipients. So if you have an employee who suddenly comes back to you and has a work authorization, and you had an I-9 before that had been filled out, and you presumed that he was lawfully employed, but now he's, based on an executive order, has a new work authorization. What does that mean for you as the employer? What can you expect? Well, you can expect to probably fire and rehire this person under all this new documentation. You can also expect the possibilities that if there's an executive order issued, we'd hope that the executive order would include some kind of waiver for employers who now have these new employees in their workforce who had been there before working, perhaps with false documents that the employer was unaware of, but now has a work authorization. I'm always thinking of how to protect my employer, and the best way to approach that scenario would be to write a memo to the file based on executive order, blah, blah. This employee came in with work authorization. We are reissuing an I-9 based on the new information, and include that with the old I-9. Another area that was also in the original reform that was passed by the Senate but couldn't budge through the House was work authorization for those who work in agriculture. We could potentially expect work authorization for those who are helping in farms, hopefully dairy, and other areas that are crucial to our economy. The other area that we can see is increase employment-related visas. We work a lot in skilled worker visas as well as unskilled worker visas, and I'm going to give you the example of both. H-1B is a type of visa that allows an employer to hire a foreign national who has a degree, bachelor's degree or more. They're considered a specialty occupation. Those visas, the doors first open up on April 1st of every year. And this is like a mad rush. We as practitioners literally run to the doors and we have our packets ready. So on April 1st, they are actually arriving at immigration. First in, we want to be the first ones there. Yes, and so do 197,000 other participants who want to be the first ones there. On April 1st of 2014, all the work visas for H-1B were consumed. There are 60,000 visas and 179,000 applicants. So everyone went into a pool and there was a drawing. And if you were lucky enough to get one of those visas for your employees, hallelujah, we celebrate. If you weren't lucky, do you know the next time you can file for that visa? You can file for that visa on April 1st of 2015, so they can start working on October 1st of 2015. Well, we could potentially accept or see an executive order increasing the number of employment-related visas. We have a great deal of momentum with employers who find themselves both advertising and waiting for employees to fill slots that are simply not being filled. The other thing we could potentially see is an extension for those foreign nationals who graduate from the United States. Right now, OPT or OPT, Occupational Practical Training, is a year-long opportunity for a foreign national who has just graduated to work for an employer in the United States. A possibility of an executive order could be to extend that year to a 2 or 3 year period so those foreign nationals can get not only experience, but also the opportunity to work for a longer period of time and transition into a work-related visa. These extensions are extremely important in certain areas, not only in the tech industry, or the STEM, which would be science, technology, engineering, and math, but certainly in other areas, marketing, business, teachers who have the opportunity to work. I can't tell you how many employers I get who are trying to get teachers who have a specific area of knowledge, whether it's science, math, language, music, whatever they might be, and they advertise and they'll get somebody working for them for a month, for a week, and then they're gone. It puts employers in a very precarious situation. An extension of an OPT or an occupational practical training for those foreign nationals who are students here and graduated would give an employer an opportunity to not only test that employee, train that employee, but also decide whether or not this is an employee that they would like here long term. And then the other alternative would be those who are married to US citizens who have entered the United States illegally, a process to provide legal permanent residency for spouses of US citizens who entered illegally. Let me tell you how it works right now. Right now, if a foreign national enters the United States unlawfully, regardless of their age, maybe they entered as a child, maybe they even have in their hand work authorization that was issued to them through this program known as DACA, or Deferred Action for Childhood Arrivals. They marry a US citizen. Seems like the norm. They've been here all their lives. They probably are dating US citizens, and they marry this US citizen. The presumption is, oh, piece of cake. They get married, file for a green card, and then she has her citizenship. I can't tell you how many potential clients call on a consultation and say, well, I married a US citizen. Can I get my citizenship now? It doesn't work that way. If you entered unlawfully, you will not get legal permanent residency in the United States. The process provides that you first have to apply with a petition known as an I-130. That petition is taking about a year to process. Then, if you're lucky enough to qualify for something called a provisional waiver, then you apply for a waiver. And what that waiver tells the government, it says that a US citizen's spouse would suffer extreme hardship if their foreign national spouse had to be sent and remain in the United States. They need to provide psychological records, emotional declarations, economic or health hazards that the US citizen would suffer if they A, had to go and live in a foreign country, or B, had to be separated from their spouse. That little piece of the puzzle takes about 4 to 6 months. And then let's jump to the last hoop. The last hoop would be for them to be able to go and get their actual green card. That requires them to go outside the United States with an approved waiver, go to an interview in their foreign country, and then be allowed to re-enter. Certainly, an executive order allowing spouses of U.S. citizens to legalize their status in the United States would be beneficial and avoid all these long, convoluted, complex, and at times very difficult steps for foreign nationals and U.S. citizens. We may potentially see executive orders after November 5th, 2014.